A lot of discussion lately about so-called large capacity magazines, which you know is a propaganda term for standard capacity magazines that everyone owns in their basic semi-automatic rifles and semi-automatic pistols. Either way, though, it's very important that you understand how to analyze these kinds of cases because these keep popping up. There's a major one in California, one in Oregon, and one coming up in Washington State. And I want to make sure you understand the nitty-gritty of how this works. Very important to get this right. A lot of people, including judges, will get this wrong. But don't fear. We'll solve the problem and lay it out for them nice and easy right here and right now. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and yes, New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Okay folks, standard capacity magazines. This is a hot topic now. It's going to be a hot topic going forward. It's complicated, but not really, because I'm going to break it down for you so you really understand it. For a lot of people, though, there are complicated issues involving this topic because it involves two things that get people confused right now. I'm going to clear it up for everyone in America. It will all be fine. The issue involving standard capacity magazines, which is what I'm going to call them, but standard capacity magazines that hold more than 10 rounds, whether it be for a pistol, handgun, or, of course, a long gun, is really answered at the end of the day by the decision in Heller versus DC. Why is that? Well, you see, Heller versus District of Columbia dealt with another gun ban case. In the District of Columbia, DC banned the possession of handguns of all sorts. And even anybody who could touch a gun had to have them in a trigger lock. But the Supreme Court fixed all that in Heller. And the way it did it is it engaged in a test. And this test ultimately gave rise to the Bruen test. And I want to, first of all, for the purpose of this video, I want to break it down this way. I want to walk through the proper interpretation of Bruen and Heller, how it should be applied by judges, law clerks, and lawyers, and academics, based on, not my opinion, but the actual text of the United States Supreme Court decisions in Heller, McDonald, Catano, and yes, Bruen. It's actually quite easy when you walk through it, but it's a little complicated the first time you walk through it. And let me show you why. So let's step back. How does one analyze a lawsuit involving the Second Amendment as applied to a modern-day gun control law? Well, let me tell you how it works. If you go back to Heller, and by the way, the methodology of how Heller decided whether or not the DC handgun ban was constitutional, and it concluded it was not constitutional under the Second Amendment. That methodology is really the same methodology that Bruen is now telling every court in America to apply. The only difference is that Heller did the analysis and, as best I can tell, assumed that the lower courts would understand how to do it and would follow along accordingly. But as it turns out, as we know from history, that for 10 years or so, lower courts screwed up how to apply the Second Amendment 10 ways to Sunday, or 6 ways to Sunday, pick your metaphor. So the Supreme Court had to come back in NYSRPA versus Bruen and clean up that mess, which they did. So let's break it down. So in Heller and then in Bruen, and by the way, Bruen basically embraced Heller and clarified Heller or expanded upon Heller, whatever you want. So really, at the end of the day, and this is where it gets a little confusing, but it's not hard to understand once you realize what's going on. The Bruen methodology for interpreting the Second Amendment and resolving disputes about the Second Amendment as to modern gun control laws, the Bruen methodology is actually the same methodology that Heller did. The only difference is that Bruen was a little bit more robust and more explanatory to help the lower courts understand what to do, because they obviously felt that the lower courts did understand what was being conveyed in the Heller case in terms of how to approach these cases. So the way this works is as follows, and they do the same thing in Bruen and Heller. Step one is you look at the text of the Second Amendment. And step two is you do history. Now, I know they talk about how the two-parts test or the two-step test is not acceptable. And that's true based upon what happened in the last 10 years, because the two-part test that the courts were engaged in was a shady version of the two-part test. Well, the problem was not that there was two parts. The problem was what the two parts consisted of. Because over the last 10 years, basically the lower court said, well, if it involves banning guns inside the home, that's a very special protection and we have a heightened standard. But if it involves any other gun control law in America, we're basically going to apply some balancing test, which we're going to label tiers of scrutiny, and we're going to uphold that gun control law. So the Supreme Court in Bruen says that version of the two-part test, which involved balancing or tiers of scrutiny, was totally unacceptable. In Heller, it was totally unacceptable in Bruen, and said you can never do that ever again. You cannot do the balancing test or the two-part test involving balancing ever again. That is verboten. That is banned from now on. So what instead has the Supreme Court done here? Well, what they really have done is a text and a history test. And I'm going to break it down so you understand it very simply. The way to think about it is you look at the text first, the text of the Second Amendment first, and then you look at the history associated with the long-standing or the alleged long-standing traditions of regulating guns in America. So let me break that down for you. Again, step one is that if a plaintiff in a Second Amendment case identifies a modern-day gun control law they want to strike down, for example, the magazine bans where magazines hold more than 10 rounds, they see that law and they say, well, does it infringe upon, does it touch fingers with, does it implicate in some way the text of the Second Amendment? And the answer is, of course it does. But how do we reach that answer? Well, what happens is you look at the text of the Second Amendment, but as we've talked about on this channel before, you don't just lower courts don't just get to read the text of the Second Amendment and make it up. It's not how it works. No, what the lower courts have to do is to read the text of the Second Amendment. And then they look to the Supreme Court precedent, which has defined and interpreted the various words in the Second Amendment. Because if you look at Heller, they defined basically every word in the Second Amendment. They defined the people as all individuals in the United States. All Americans are part of the people, as in the right of the people to keep and bear arms. They defined to keep as to possess, to have. They define to carry, they define to keep as to carry. To keep means to possess, to bear means to carry. They then defined arms, and this is very important for the purposes of the magazine cases. They defined arms specifically as arms that are bearable arms, which means you can carry them. Specifically, the Supreme Court in Heller defined arms based in the 1773 edition of Samuel Johnson's dictionary, defining arms as, quote, weapons of offense or armor of defense. Weapons of offense or armor of defense. Samuel Johnson, 1773, the Supreme Court quotes him and that definition in Heller. Timothy Cunningham, another famous lexicographer at the time of the founding in 1771, defined arms as, quote, anything that a man wears for his defense, or takes into his hands, or useth in wrath to cast at or strike another. 1771, Timothy Cunningham. Noah Webster, the first American lexicographer, which is a fancy word for guy who makes up dictionaries. Noah Webster, you probably have a Webster's dictionary at home. It was named after Noah Webster. Noah Webster did the first American dictionary of the English language in 1828, and he basically used the exact same type of definitions of arms. And what the Supreme Court did, and this is going to be extremely important, and you'll see why, and I'm taking my time on this because it's very important for judges out there, law clerks, lawyers, anybody that really wants to get this right, precisely right. I'm going through that for your benefit right here and right now because, again, it's a little complicated, but not when you break it down. It becomes very clear when we break it down, which is what we're doing right now. Okay, so the Supreme Court in Heller defines arms, which appears in the text of the Second Amendment, it's the right of the people to keep bear arms. But then the Supreme Court goes on in Heller. Again, this is not what I'm telling you. I'm not just blogging stuff and making stuff up. I'm telling you what the Supreme Court has told all of us, including lower court judges. Okay? Here's what the Supreme Court wrote about arms. They said that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, close quote. Again, not Mark. The United States Supreme Court in Heller defines arms, as in the right of the people to keep and bear arms, as the following, quote, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, close quote. Now, why am I telling you this? Why is this important? Because remember what I told you. There's a two-part process to the methodology of Bruen. The first part is you look at the text of the Second Amendment. But you don't just look at a text in a vacuum. You look at the text of the Second Amendment along with the definitions and interpretations of those words by the United States Supreme Court, which means that lower courts like in Oregon or California or Washington or other places or New York, they're not allowed to make up what they think the text means. No, they have to interpret and apply the text of the Second Amendment as it's interpreted by the Supreme Court. And you just heard that term, bearable arms. That's going to come back and play a very important role in the magazine debate, and you'll see why in just a moment. Now, so there we have it. We know that bearable arms are part of the definition of arms. So when a judge does a test involving a ban on magazines that carry more than 10 rounds or hold more than 10 rounds, the first thing that judge should do, and will do almost certainly if they're smart and know what they're doing, and take this seriously, and take their instructions from the Supreme Court seriously, they will apply the plain text of the Second Amendment as interpreted by the Supreme Court. They will then conclude that arms is all bearable arms, instruments that are bearable arms. Okay? Now, the question is, and we're going to talk about this more specifically in a separate video because it warrants a separate video. Are magazines arms? And the answer is, in short, yes, they are. And I'm going to break this down in extreme detail in a separate video. But in short, magazines are indeed arms under the Second Amendment, even though they in and themselves are not firearms. And the reason why magazines are arms is for several reasons off the top of my head. First of all, we know they're used for self-defense and defensive purposes because every single one of these statutes that bans magazines that carry more than 10 rounds or hold more than 10 rounds exempt law enforcement. Well, why are they exempting law enforcement? We know why they're exempting law enforcement, because these magazines are self-defense tools that go alongside and are necessary for semi-automatic handguns and rifles. Number one. Number two, so obviously they have a self-defense component. Because they have a self-defense component, obviously, because they are used for self-defense, they are an instrument. They are an instrument that constitutes a bearable arms, right? And Samuel Johnson, of course, says that indeed, they are an instrument that can be used either offensively or defensively. So therefore, they're protected. Okay, that's number one. Number two is, of course, these magazines. Many magazines could be fixed magazines, which means they're an essential component of the firearm because they're actually fixed to the firearm. And even if they're detachable, which most magazines nowadays are detachable, they're also an essential, necessary component for that firearm to fire. Sometimes they're actually a safety mechanism, meaning the gun won't fire unless the magazine's actually inserted, Other times, of course, these magazines are specifically designed per gun. So if you use like a Glock magazine, it's not going to fit in like an AR magazine for a different manufacturer. You get the point. So these magazines are specifically designed for specific guns to make sure those guns work. Beyond that, of course, we know that even under the Ninth Circuit law of California, not exactly a gun-friendly jurisdiction, we know that things are essential to make a modern-day gun work, like ammunition. Even the Ninth Circuit says that ammunition, even though the word ammunition is not mentioned by the plain text of the Second Amendment, right? The word ammunition is not in the plain text of the Second Amendment. You can't see the word ammunition there. It's not there. But it's necessary or important for the functioning of an arm, and therefore ammunition is considered a protected arm under the Second Amendment, even though it's not mentioned. And that's why the Ninth Circuit Court of Appeals has reached that conclusion. Obviously not necessarily a gun-friendly area, and they even concluded that ammunition are protected. So obviously a storage device for ammunition should also be a protected arm. And last but not least, we know that magazines are arms, and this requires a little bit of step back abstract thinking, but just think for a moment. Heller said that you could not ban handguns, which is a type of arms. Now, Heller said you can't ban any handguns. All right? Understand? Handguns. They talk about handguns. They didn't talk about Glocks versus SIGs versus Ruger. No, they talk about handguns generally. A type of firearm, a class of firearm. Now, if you think about a magazine, if you ban a magazine or magazines or the use of magazines or possession of magazines that hold more than 10 rounds, what have you done? You actually have engaged in banning firearms themselves. A class of firearms has been banned by virtue of banning magazines that hold more than 10 rounds. Why is that the case? Well, think about in the state of, let's say, Washington or Oregon or California. If you want to own a firearm in your home to keep or to carry to bear, to keep or to bear, a firearm that holds, let's say, 20 rounds, and the law says you can't have a magazine that holds more than 10 rounds, that law, in effect, is banning all firearms that hold more than 10 rounds. That law is banning all firearms that hold, for example, 20 rounds, or all firearms that hold 17 rounds, or all firearms that hold 30 rounds. So a magazine ban is actually a gun ban, because the magazine, where you ban a magazine from holding more than 10 rounds, you are essentially saying that any class of firearm in the state that holds more than 10 rounds is hereby banned. That becomes a gun ban. And because it becomes a gun ban, guess what? Heller applies. And what does Heller teach us? Gun bans are not allowed. Supreme Court precedent, right on point. Boom. Boom. We win. But let us continue. So again, step one of the Bruen methodology is you apply the text. Once the text is implicated, and here we know that the right of the people to keep and bear arms includes the right to keep and possess and the right to bear and carry magazines which are bearable arms for the reasons I just articulated as to why magazines do fall within the definition of arms in the same way that ammunition falls in the definition of arms, among other things. And by the way, I'm not aware of a single court in America as of, I don't know, a month ago. I don't know where we are in the last few weeks, if there's some court out there or something craziness. But as of like a few weeks ago that I'm aware of, I'm not aware of a single court, a federal court in America, that has concluded that magazines are not arms under the Second Amendment. Some have assumed that they're arms, but the bottom line is no one's ever concluded they're not arms. And I don't think they could, because if they did conclude that magazines were not arms, then in theory, they could limit all of us to a single shot handgun, because they could in theory ban all magazines that hold more than one round, right? And if they did that, that means we'd be back to a single shot handgun or a single shot pistol, but we know that's not allowed because the Supreme Court has specifically said that what's protected are modern arms. But we're going to get to that in a second. So again, you take the text, you apply the text as defined by the Supreme Court. I just told you that magazines are arms. We can break that in extreme detail, but I'm not going to do that in this video. Just assume for the sake of the argument, based on my quick observations, that magazines are arms. So now that the text is satisfied, a ban on magazines that hold more than 10 rounds triggers or touches fingers with or implicates the text of the Second Amendment. And once that happens, that gun ban is presumptively illegal. It presumptively unconstitutional and presumptively must be struck down as unconstitutional. So what happens next? And this is a key point. Do not screw this up. I repeat, do not mess up what I'm about to see, folks, if you support the right to keep and bear arms, because the anti-gunners are trying to conflate things. Do not let them do this. Do not screw this up, what I'm about to say. Very, very important. Once the text is implicated, the purpose of, then you go to step 2 of the Bruen methodology, which is the historical tradition part. Now, the way to understand the purpose of the history is as follows, and you repeat it after me, and do not forget this. The text giveth your rights. I'm going to comment right now. The Second Amendment does not give you rights. They are pre-existing human rights. The Second Amendment recognizes your right. But set that issue aside. I don't want to talk about that right now. I want to talk about how to analyze Bruen correctly as a methodology. Set that point aside. It's completely correct, but I want to talk about the methodology. The way to understand this conceptually, so you don't screw this up, and you cannot screw this up, or it will be catastrophic for our rights. The text giveth the rights. The text tells you overall, broadly, what is protected. But the history, according to the Supreme Court, the history has the potential to taketh those rights away. It's not necessarily a bad thing, but this is the way to think about it. The text giveth our rights, the text taketh our rights away conceptually, if that history is there. And what I mean by this is, once the text implicates the right to keep and bear arms, the burden goes to the government to show a historical analog or historical tradition of what? Of long-standing, going back to the time of our founding of 1791 when the Second Amendment was adopted, right? A historical tradition going back to the founding period, 1791. You've seen my articles in the Harvard Journal of Law and Public Policy. You've seen my articles. I explain in great detail. I'm sure courts are going to rely upon it. If they were smart, they would. But anyway, I digress. So the historical tradition goes like this. Once the text is implicated, you go to the history. And the Supreme Court says the burden is on the government to show that there is a long-standing tradition of regulating firearms in the same manner that the modern-day gun control law exists, and that has to go back to 1791. A long-standing tradition doesn't mean it starts in the 1950s. It actually has to start in the 18th century. It has to start with the 1700s or maybe the early 1800s at the latest. But it's got to start during the founding period to be a long-standing tradition of regulating firearms in America. Okay? So again, you got the text first, triggers that it's protected, presumptively protected. Then the government at that point has to use history to try to demonstrate there are historical analogs, historical examples of gun control laws at the time of the founding that are analogous, sufficiently analogous to modern gun control laws to allow them to stand. Okay? So for example, a long-standing law that we would all agree with that went back to the colonial period is you cannot use firearms to illegally conduct business. You can't use guns for bank robberies. You can't use guns to commit crimes. You can't misuse firearms in all sorts of ways. Okay, those are long-standing regulations of firearms, and of course, those would be upheld today because you can't engage in the misuse of firearms and misuse firearms to commit crimes. For example, that is the kind of thing we're talking about, a long-standing history or a long-standing tradition of gun regulation in America going all the way back to 1791. Those would be considered, the kinds of activities and modern-day gun control laws that would be upheld under the Second Amendment and consistent with the Second Amendment and not violate the Second Amendment. Again, we got the text, we go to the history. Now, let's talk about magazines, okay? And this also applies to a so-called assault weapon, semi-automatic rifle bans as well. And this is the other thing. So, okay, actually before I get there, this is the critical thing to not screw up. Critical thing to not screw up. I'm going to talk about the common use test. The common use test is the test that shows what arms cannot be banned. But this is a critical point. Do not mess this up. The common use test occurs in the context of the Bruen methodology in the history part of the analysis. I repeat. You do the textual analysis of the Second Amendment first. All you need to conclude for protecting an arm from a gun ban is that that arm is a bearable arm, which means it's carryable. That's it. That's it. The burden shifts to the government to do history. They have the opportunity to show long-standing historical analogs of some sort of gun regulations that are consistent with and support modern-day gun control laws. And it is in that point in time, during that historical battle between the two sides, pro-Second Amendment anti-gunners, it is during this historical fight where the common use test, meaning guns that are commonly used for lawful purposes by Americans, are protected. It is in this context when the burden is on the government, to find historical analogs, when the burden is on the government to show and demonstrate a long-standing historical tradition, that the common use test comes into play. Under no circumstances, you cannot mess this up. I cannot stress this enough. Under no circumstances can you allow, or should you argue, or should you make the case that the common use test, which we're going to elaborate on in a second, you should never let the common use test play a role in how you understand the text of the Second Amendment. And what I mean by this is this. The arms protected by the right of the people to keep and bear arms, the arms protected is simply the instruments that are bearable arms. That is all you need to trigger Second Amendment protection and presumptively unconstitutional modern-day gun control laws. That's it. That's it. What the anti-gunners are trying to do, and you must not let them do this, is they are trying to say that at the first step, before you shift the burden, if you will, to the government to demonstrate that they can ban guns, the anti-gunners are trying to say that, the only guns protected are those in common use by Americans for lawful purposes. And specifically, they're saying commonly used by Americans for self-defense. And they're trying to confuse judges into saying that that test is not part of the history part of the methodology where the government bears the burden. They're trying to persuade judges that that common use test, which we're going to break down in a second, is actually part of the textual analysis where if the burden exists on anyone, I don't think it would exist if anybody, it could potentially exist with the pro 2A plaintiffs to show that they're commonly used. But that's not how it is, because the common use test arises from analysis and evaluation of history in Heller. Okay? So again, when we talk about common use, it is not part of step one textual analysis. Does the plain text cover common use guns? No. Plain text just has to cover bearable arms. You go to history, the burden is on the government. And now, let's talk about that historical burden. What is the burden on the government when we shift to history? Now, when we talk about all sorts of other kinds of gun control laws, sensitive places, which are gun-free zones, we talk about 18 to 20-year-olds. We talked about restrictions on where you can bring a gun or how you can use a gun, things like that. Those issues have not been robustly decided yet by the U.S. Supreme Court, okay? So we're not going to get into those. I just want to talk for the purposes of the magazine ban, which at the end of the day is an arms possession gun ban, right? It's an arms possession ban. They're banning you from possessing arms, whether it be an assault weapon, AR-15 style semi-automatic rifle, or a magazine, a large capacity magazine, which is standard capacity magazine holding more than 10 rounds. Those are arm bans, arms possession bans, okay? Now, once you're in a gun ban context, here's the good news. This is the other mistake you cannot make. The good news is that once you are showing that an arm has been banned by a government law, the only issue left is simple. Are those arms commonly possessed by Americans for lawful purposes? I repeat, once you're dealing with a ban on a gun, a ban on a magazine, where possession of that is banned, there are no more historical analogs. The government cannot win that case by bringing forth new historical analogs. The only thing the government can do to win a case where they ban arms, whether it be magazines or semi-automatic rifles, the only thing they can do to win that case is to show that the type of arm being banned, like a semi-automatic handgun, a semi-automatic rifle, magazines that hold more than 10 rounds. They would have to demonstrate and bear the burden to show that those arms are not commonly used by Americans for lawful purposes. It's impossible for them to prove because it's simply, obviously not true. Because we know there's somewhere between 20 and 40 million AR-15 style, AK-47 style semi-automatic rifles in America. And we know there are somewhere in the order of magnitude of 2 to 500 million. I repeat, 200 to 500 million magazines that hold more than 10 rounds in the United States already. That is clearly commonly possessed for lawful purposes by Americans. To put that into context, the absolute number that we're talked about involving stun guns being commonly protected arms in the Caetano case in 2016 by the Supreme Court was 200,000. So we know that, whether it be 20 to 40 million AR-15s, that's more than 200,000 in Caetano stun guns. And we also know that, 500 million or hundreds of thousands of magazines holding more than 10 rounds is certainly larger than 200,000 stun guns talked about again by the Supreme Court in Caetano. So we know that once magazines are deemed arms, which they are because they're an essential component of a gun, and once they are commonly used, it's game over. It's game over. It's game over. We've won the case. We've won the case. Now, this is critical to understand this. The anti-gunners, and I actually read the papers in the Duncan case in California. And I did that. I actually wasn't planning on reading them initially because I've been so busy with other stuff, but I did pick them up and I read them, and I noticed actually, thank you plaintiffs out there in California, I noticed that the first thing cited and actually quoted by the Second Amendment plaintiffs in that case was actually an article I wrote, and they were quoting Mark Smith. And I think that's a credible source, but we'll see, right? So when I saw that, I did skim through the papers, and then I looked at the state's papers, and I realized a lot of terrible flaws in the arguments of the state. But what I did notice in the state of California's arguments was they're trying desperately to do something that's totally unacceptable and not allowed. It's irrelevant, completely a waste of time. They're trying to bring in all these experts. They're trying to bring in all this history. All the history, by the way, is totally nonsense. It's too late. It's not persuasive. It's going nowhere. But it's, to me, from my review of the state's papers in California, they're trying to buy time. They want to delay. I don't blame them because they're going to get their butt kicked if the Bruen methodology is properly applied. But here is why all of the arguments by the state are basically losers when it comes to history. You see, Heller did the history already when they did the gun ban case in D.C. And what I mean by this is Heller was a gun ban or an arms possession ban, right? You could not possess handguns in D.C. Now, that is exactly analogous to the California, Oregon, Washington bans on large capacity magazines or standard capacity magazines that hold more than 10 rounds, let's say. They're the same. They're gun bans. They're arms bans. Now, in Heller, they went through and they did the textual analysis. They then shifted the burden to the government. And then they themselves looked at the history of gun bans in America. And they basically said that there are no gun bans in America. The only exception to that, the Supreme Court said in Heller, was this. And this is why we win this case. Slam dunk. Slam dunk. The Supreme Court says the only conceivable arms that can be banned in the United States under the Second Amendment are arms that are, quote, dangerous and unusual. Dangerous and unusual. Now, I should make a side note here that in the California brief, they're trying to say that guns can be banned if they're dangerous or disjunctive unusual. That's total BS. And not accurate in any respect, as I see it, because the Heller decision talks specifically about the only types of guns that can be banned are those that are dangerous and conjunctive. Together, you got to be both, dangerous and unusual. Now, what the anti-gunners, I think, are trying to argue is they're trying to quote some older Blackstone commentaries where Blackstone's commentaries talk about dangerous or unusual. But Blackstone's commentary is persuasive, but he's like an English lawyer. He's like an English dude lawyer, persuasive, important, but he's not American law. The Supreme Court uses Blackstone to interpret the Second Amendment. We don't embrace all English law in the 18th century. We use it to interpret sometimes our American law. And in America, according to the U.S. Supreme Court, you can ban dangerous and unusual arms. You cannot, it's not the test of dangerous or unusual, but California is trying to argue dangerous or unusual, but the truth is that's not the standard, and that's pretty obvious. The Supreme Court in Heller makes it clear it's dangerous and unusual. Now, why am I telling you this? Here's why. The only way the magazines that hold more than 10 rounds could be banned under California law or under Oregon law or Washington law or any of these other places that have so-called magazine bans, the only way those can be upheld constitutionally would be if those are dangerous and unusual. But it is absolutely 100% impossible for these magazines that hold more than 10 rounds, and it's absolutely positively impossible for semi-automatic rifles if you apply these tests correctly, to be dangerous and unusual. And why is that? What does dangerous and unusual mean? What is the last word of that phrase? Dangerous and unusual mean. Unusual means unusual. And by definition, what is not unusual? By definition, what is not unusual is something that is common. Common. And the Supreme Court has said specifically that in Heller, that because handguns are commonly used by Americans or commonly possessed by Americans for lawful purposes, they're protected. Well, guess what? Magazines and semi-automatic rifles are commonly used, they're commonly possessed by Americans for all lawful purposes, and therefore they're protected. And therefore there's no way the government has any possible way to show that they're dangerous and unusual, because these magazines that hold more than 10 rounds and semi-automatic rifles are obviously can't be unusual because they're obviously commonly owned in America by virtually everyone in America outside of, a handful of blue states that would own them if they could, but they're being barred in various ways by the anti-gun places. Okay, so let me summarize. I know this is a longer video, but this is mission critical. So again, here's the key point. Here's the key point when it comes to common use. All those experts in California, all those arguments and all that material and all that discovery and all this information the state wants to get in California, and I presume they're going to want to do the same in Oregon and these other places. When it comes to banning arms, whether it be a magazine or banning a semi-automatic rifle, none of that, I repeat, none of that is relevant. None of it can be used, including the history. The historical analogs, to the extent they existed and are relevant to the Supreme Court involving ban cases, meaning gun possession ban cases, arms ban cases where you ban the possession of an arm, whether it be a magazine or a gun, a handgun or a semi-automatic rifle. The test, the analysis, has already been done by the Supreme Court. They've looked at the text. They've looked at the history. They looked at historical analogs. They did all that work. And what did they conclude? The United States Supreme Court said that unless the gun is dangerous and unusual, which means by definition it's not common, then you can't ban it. And because handguns and of course semi-automatic rifles and magazines are commonly used by Americans for lawful purposes, you can't ban them under Heller. No amount of historical precedent, no historical analogs, no amount of discovery, no amount of anything that the anti-gunners would need could possibly overturn or get around that decision. Because Heller has already done all the work when you're dealing with a case involving banning an arm and banning semi-automatic rifles and naming them assault weapons, or banning magazines and calling them large capacity magazines, are gun ban cases. They're arms ban cases. Once you're in an arms ban context, you apply Heller. And once you apply Heller as understood and articulated by Bruen and elaborated upon by Bruen, it's game over because the text is implicated. Now the burden shifts to the government, and the government is lost because the Supreme Court already articulated the test for banning these guns, which is, well, if they're commonly used by Americans for lawful purposes, you can't ban them. Boom, it's over. There's no more analysis needed because the Supreme Court already did the work for you. Think of it this way. It's kind of like if your kid comes home with 20 math problems and you do the first one with him, you've already done it. You've shown him how to do it. It's already done. You don't need to go back and redo number one. He now needs to take the methodology and teaching points from the first math problem he did and apply to the other problems. And that's what Heller did. Heller taught the courts how to deal with a gun ban case, a magazine ban case, an arms ban case. And the test is, as long as it's commonly possessed by Americans for lawful purposes, it's protected. One last point I want to make about this magazine thing. The anti-gunners are trying to say it. And this is another little trick. It's not going to work. You got to be crazy to buy into this argument and not be able to read, as far as I'm concerned, if you're a judge. But let's not get into that. Let's just be very precise. So again, the anti-gunners are arguing that the Second Amendment plaintiffs, and this is why it's so important, the Second Amendment plaintiffs bear the burden to show that these magazines or these semi-automatic rifles are commonly used for self-defense by Americans. That is not the test. I'm not making this up. Just read Heller. Read the Supreme Court's decision in Heller. And what do they say? The Heller court specifically says that guns or arms that are commonly possessed for lawful purposes such as self-defense are protected. Such as self-defense are protected. Now, what's going on here is that because Bruen dealt with self-defense outside the home, because Bruen, on its facts, were dealing with individuals that want to carry guns for the purposes of self-defense outside the home, a lot of the Bruen language dealt with self-defense as commonly possessed for self-defense because they were talking about carrying handguns outside the home for self-defense. But nothing about Bruen got rid of the Heller test. And Heller specifically says, in fact, Bruen just elaborated and strengthened and pointed out how to do the Heller test properly, which again is you start with the text. Once you meet the text, you go to the history, and the government bears the burden to show the historical tradition, which they can almost never do because there's not a lot of long-standing traditions involving regulating firearms in the United States, going back to the founding. So again, what the anti-gunners are trying to do is to say, well, if you read Bruen, it talks about self-defense. Yes, but Heller is still good law. Heller hasn't gone anywhere. It was just elaborated on and clarified so the lower courts would get it right going forward because they were playing games with how they applied Heller. No more, because Bruen basically took the Heller methodology, elaborated upon it, clarified it, and gave it back to the lower courts and said, don't mess it up again. Get it right this time. I'm not going to tell you again. Go get it right. That's what they did in Bruen. They took Heller, cleared it up, illuminated it up, gave it to the lower court, said get it right. Now what's interesting is in Heller, again, the commonly possessed firearms that are protected are those that are held by Americans for lawful purposes, all lawful purposes, not just self-defense, but including self-defense. But of course we understand, and I'll leave you with this point. I know this is a longer video, but this is very important. Very important. We know that merely possessing a handgun or merely possessing arms, whether it be a magazine or a semi-automatic rifle, merely possessing guns, first of all, you have a right because it's the right to keep and to bear, right to have and the right to bear, meaning to carry. We have the right to carry. But again, the reality is that having a gun in and of itself is using a gun. The most basic example I like to use is when a police officer is walking down the street just holding a gun in his holster, he's using the gun. When you carry a gun, you're using the gun. When that gun is in your nightstand beside your fire extinguisher, you're using the gun. You're using that fire extinguisher. You may not be pulling the trigger and shooting it. You may not be picking up the fire extinguisher and spraying it, but you're using it. It's there because as the Supreme Court said in Heller, the purpose of guns, one of the purposes of guns is for self-defense, specifically to have a gun at the ready in anticipation of a potential confrontation where you're going to need to use it to save your life. And we know it's a fact because in the Supreme Court's decision in Heller, they specifically, and people don't talk a lot about this, but it's true, the Supreme Court in Heller actually banned and got rid of and kicked out of court, kicked out of the country, requirements that handguns in the home have trigger locks. Why? Because the Supreme Court says the purpose of these guns is to have the gun at the ready, loaded and unlocked. So if you need to use it, you can use it. And they got rid of the trigger lock requirement that DC imposed that says if you have a gun in the home, you have a handgun in the home, you got to have a trigger lock on it. The Supreme Court in Heller specifically says, nope, can't do that because you're denying people the ability to use a gun for its intended purpose of, among other things, self-defense. Have it at the ready for confrontation in the event you need it to save your life. Okay, I know that was a long video. Hope you learned something about how to analyze magazine cases under the Second Amendment. Make sure you do the text first. All instruments that are bearable arms are protected. Once you've established that, the burden goes to the government to demonstrate a long-standing historical tradition going back to the founding of regulating guns in the manner they're trying to. But when they're dealing with a gun ban case or banning any kind of arms, which includes banning bullets, ammunition, or magazines, for example, then you simply have to apply the Heller test as explained by Bruen, because the Heller test is still good law and explains that when you're dealing with something that's commonly possessed by Americans for lawful purposes, you cannot ban them. Because by definition, those are not dangerous and unusual, which is the only conceivable type of arm in America that can possibly be banned. But magazines, bullets, parts of firearms are all arms. They're all protected. And if they're commonly used by Americans for lawful purposes, which all the things we're talking about clearly are, it's game over. The defendants of the state, California, doesn't get another bite of the apple to come forth with historical analogs or anything like that. That's already been done. The product of the historical and textual analysis done by the Supreme Court in Heller was done, gave forth to the common possession test. That is the only thing that applies. Everything else is noise and nonsense and doesn't need to be heeded. Although the anti-gunners certainly want courts to be confused into doing all sorts of other things to delay the inevitable. But again, they shouldn't be allowed to do that because that would be inconsistent with what the Supreme Court has told lower courts to do. Okay, hope you learned a little bit something here today. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.